questioned as implied by Advocate Noko, which is what you've said.
That is correct, Chair.
And now let's see what is said.
Sorry. In 781, were you the only investigator? Or you had a team under you?
No, or the team under me.
Okay.
Yes, Chair.
Well, that's fine.
Now, back to page 121, at paragraph 2.9, this is said, Major General Boyson, being the complainant in the 466 case, interfered with and exercised control in this case, even going to an extent of determining and deciding on who visits Colonel Madu when he was detained in Durban Central Prison cells in the 466 case. This is exhibited by the letter that was issued on his direct instruction to the Durban Central Police Station Commander, Brigadier Stokes. This letter dated the 16th of September 2011, addressed to all relief commanders and cell commander titled Visitation Durban Central Madu, provides that on the direct instruction from Major General Boyson, only the following persons will be allowed to visit him. Major General Boyson to Major General Mudley. What is amazing with this is that Major General Boyson issues an instruction regarding who must visit a suspect in a case that is the complainant himself. Further, he also has a visitation right in this, as it appears in the letter, him among those who are allowed to visit Colonel Badu. By the way, what would a complainant want to visit a suspect in their own case for? This is unheard of and smacks of an agenda. Can you comment on that?
I only became aware of this letter at the later stage, Chair. That's the only comment I can make on this.
If I can tell you to go to page 132, what Colonel Boyson's response was, and perhaps you can comment on that. At paragraph 2.9, Advocate Noko is seriously misguided to suggest that I interfered with the exercise control in Durban Central Case 466. Had she complied with the NPA policy guidelines, she was at liberty to consult with me to establish the facts which I shall detail below. As the provincial head Hawks, it is incumbent upon me to exercise control over all investigations conducted by the Hawks in KwaZulu-Natal. The National Directorate Head, Hawks, were kept abreast of all developments in the investigation. To suggest that I interfered with the investigation is akin to suggest that Advocate Noko herself is interfering with the functions of her subordinates. There is nothing mysterious regarding my instruction with regard to visits to Madu. Initial investigations revealed complicity by officers within SAPS. This entry into the occurrence book was made to obviate attempts by officers with malafide intentions. I have dealt with the matter regarding being the complainant above. Again, the tenor and tone of Advocate Noko's contentions appears to be that a defense counsel be that of a defense counsel rather than that of a prosecutor. The fact that I had not visited Colonel Madu at all subsequent to his arrest, or that I had not personally communicated with him directly or indirectly, demonstrates that Advocate Noko's assertion that it smacks of an agenda is misguided, and I reject it with contempt. Can you comment?
Yes, I agree with what General Boyson is saying, Chair.
And now,
Well, you are asking the witness to comment on just argument.
yes,
Really, I don't think we should spend time on this with this witness. General Boyson, if he didn't cover this when he gave evidence last year, would need to come in or at least do an affidavit confirming
yes,
that this was his memo and confirming the correctness of
yes,
this.
yes.
Otherwise, ask this witness questions that relate to matters where he can really add
Yes.
value.
There's only one final aspect that I would like you to comment on with regard to this document. If you could go to page 122, and it's paragraph 2.10. And I would like your comment on this. The allegation that the accused in 466, Mr. Pandey and Colonel Madhu, wanted Major General Boyson to predate a report in the 781 case in order to have the Section 205 subpoenas set aside, subpoenas for access to the bank account records, and consequently bribed Major General Boyson to do that, does not really hold water, because the fact is that if there has been any corruption, bribing of Major General Boyson that took place, would not make the corruption and its successful prosecution impossible, as Sections 3B and 41B of the Prevention of Combating of Corrupt Activities Act 12 of 2004 state. The alleged report in the 781 case that it was alleged was to be predated to invalidate the Section 205 subpoenas did not suffice to prove fraud or any offence against anyone.
Ms. Wenzel, that's all argument by General Boyson. It's not facts. Or a lot of it, at least.
Yes, it is.
Yes, but this witness, what do you want this witness to do about it?
What I want him to comment is this a reason? Because what is stated is, it's almost a circuitous reasoning, is that how is it possible that because there was this bribing that it can have any effect on the subpoenas, and therefore you cannot prosecute section case 466. Okay.
That's argument.
I'll take the point. If we may then go back to your statement.
What page?
Page, I think we have dealt with paragraph 13. We've dealt, I think, mainly with what is said with regard to, this is actually quite important because there's further document that was located this morning, which I would like to deal with. If we can go to paragraph 13 on page 16. Now, you've said what transpired with this draft memorandum with Colonel Jones. You've indicated that the draft memorandum, which was ultimately prepared by Advocate Nokkel, was in Colonel Jones's possession.
And that is correct, Chair.
Now, was the case then withdrawn?
That is correct, Chair.
And what then did Colonel Jones do?
Chair, what Colonel Jones then did is he actually wrote a letter to the Provincial Commissioner, Lieutenant General Kubeni, not the finance as I indicated in this correction. He actually wrote a letter to the Provincial Commissioner, Lieutenant General Kubeni, stating that the case has been withdrawn and he heard from his attorneys and that the money that was been held must be paid out to Toshan Pandey, held by the police, must be paid out to Toshan Pandey. And as far as what we could gather, none of us knew about this letter. I mean, I don't know why. Because General Boyson stopped this paying out. And Colonel Jones, writing a letter to the suspect in 781, requesting authorization to release the funds to pay out another suspect. I mean, it doesn't make sense.
That wouldn't normally be his business.
That is correct, Chair.
Yes.
So,
The suspect or his attorneys would be the ones who would be expected to write and say, now that the case is withdrawn, we believe our client should be paid.
that is correct, Chair.
Yes.
Yeah.
Okay.
You say in paragraph 13.12 that this annexure, this letter, was still to be located. Chair, the Commission investigators were able to obtain a copy of this from the National Prosecuting Authority from the docket.
The letter.
Yes, it
Yes.
is at the end of the bundle at page 399.
Don't seem to have 399.
399.
My last page seems to be
You know, but
327.
it's the same difficulty that you had, Chair. I'm now reading the black as opposed to, I'm trying to see what it is. It's page 303. What did they say? I just can't remember.
Yes.
Now, this letter is addressed to the Provincial Commissioner, and the date is the 26th of March 2014, and it says here with attached memorandum dated the 25th of March 2014 from the Prosecutor Advocate Lutsolo. A decision has been made by Advocate Lutsolo to decline prosecution. The suspect's defense attorneys and the investigators in the matter have been made aware of this decision as indicated in the memorandum. The investigators have since released all the exhibits that were seized in their lawful owners. It was brought to my attention by the defense that the state also needs to release funds that had been held back due to the pending investigation that has since been declined against the suspects involved. To avoid any civil action against the state, it is therefore recommended that the matter is finalized as soon as possible. Can you comment on that?
Chair, this is inappropriate. I mean, this should never have been done. He's got no authority to do so at all. That's all I can comment on that. Well, I don't know what his interest was in this matter, but there were surely signs that he had some interest in this matter.
Yes.
And is it correct that what is said in paragraph 4, that the investigators have since released all the exhibits that were seized to their lawful owners?
No, Chair, that's not correct.
And then, if you can have regard to a document on page 300, it's an email sent from Colonel Govender dated the 5th of August 2014 to Brigadier van Graan, and it deals with the previous correspondences regarding the actions of Colonel Jones, and you will see that you were copied on that email.
Yes, Chair.
Do you remember this email?
Colonel Governor informed me about this email, Chair.
And if we can just refer to it, it says that yesterday, the 4th of August 2014, I had a meeting, an appointment with Major General Mkute, the head of legal services, to obtain her affidavit with regards to investigation of Durban Case 781. During the meeting, she raised the fact of receiving a letter from Colonel Jones stating that the matter, which is Durban Case 781, has been brought to her attention, that it has been declined to prosecute, and Colonel Jones had stated in the letter to prevent any civil claim against the state that she may attend to the matter of the civil claim. This letter was addressed to the Provincial Commissioner. Attached letter sent by Colonel Jones for your information. Also, Colonel Jones has attached the decision from the prosecutor to his letter, which you have in possession. I then informed the General that the investigation team was unaware of this letter and there was no communication by Colonel Jones with the team. This was reported to your office as unbecoming.
Ms.
I think it
Wenzel,
means.
you are not going to read that whole email, please.
Oh, I won't.
What is the point?
Do you agree with the contents of what is stated in this?
I do, Chair.
Yes. And there is then an email dated the 31st of July 2014, appearing at page 301 to 302, from you to Brigadier van Graan with regard to this.
That is correct, Chair.
Do you confirm the contents of this email, and do you recall what it was about? If you can just generally inform the Chair.
It's just the conduct of Colonel Jones during the investigations and what happened. And I confirm that this is my email, Chair.
Just the main points in the email? Was it responding to a particular email from somebody on what, and what did it say in terms of just the gist?
It deals with this conduct of Colonel Jones, which occurred on the 30th of July, and his view in...
What did you say in the email about the conduct of Colonel Jones?
General information which we received from, and then just the second last paragraph was that the action of Officer Colonel Jones is highly questionable, as he has now affected two witnesses of the Durban Central Case 781. Because he approached Colonel Melanie Moodley, that was working in the finance office with Brigadier Kemp.
Yes, okay.
Now, after the memorandum of Advocate Noko, you said the case was withdrawn.
Yes, it was, Chair.
And then, what happened after that? Did you continue with the investigations? What did you as investigators do?
Chair, first of all, we wanted to keep the docket away.
You wanted to?
Keep the docket away from the rest of the police force.
Yes, okay. To hide it from them.
To hide it from them. So the only legal way we could do that
Yes. Why did you want to hide it from them? What did you think they were going to do?
Chair, with all the things that was going on during the investigation and the allegations and
You thought it could get lost?
yes, Chair,
Okay.
and everything about the
Yes.
Solo's letter and Noko's letter, we decided then we discussed the matter with Major General, what's his surname? Maraj. She was head of IPIT KZN at that point in time. And it's clear from the dockets, from 781, the docket 781, that police corruption is involved. And it was their mandate to investigate that. On the CAS system, you can physically book out cases to IPIT on the system. And what I did, I made sure that we booked out 781 to IPIT on the CAS system. What we then did is we took the docket and we gave it over to General Maharaj, who was the IPIT's provincial head. Then,
Yes, thank you.
then after that, we had a meeting with the national head of IPIT. and with his advocates, and they agreed there is a case, and they will see if they can take it further.
Who was
Yes.
at that meeting?
It was myself, it was General Maraj, it was Trevor White, it was Peter Ploy, it was S.Y. Governor, and the head of IPID at that stage was McBride, Mr. McBride. He was head of IPID at that stage. They were present.
And after your presentation of the docket to them, what was was General McBride's, Mr. McBride's attitude?
He agreed with us that there was a case in 781 against the people mentioned. And also, we had interviewed him with his advocates after they looked at the docket at IPID, and they agreed as well. And then, after that, that is when we were called by Advocate Gerry Nel.
You were?
We were called by Advocate Gerry Nel.
Yes, okay.
He was then in possession of the docket, so he must have had dealings with IPID.
Yes.
Yeah. But
Yeah.
then at a later stage, I heard that it was taken away from him.
He called you to come to see him in Pretoria?
He came to interview us in Durban, Advocate Gerry Nel.
Yes.
With the docket, and we went through the docket, and he agreed, yes, there is definitely a prima facie case. There's
Yes.
enough evidence.
Okay.
And then after that, it just went dead until we heard that Advocate John Abrams gave instruction to reinstitute the charges.
So in terms of the view that Advocate Gerry Nel took of the matter, the matter should have been reinstated,
Yes,
but
Chair.
nothing happened for a number of years.
Yes, Chair, and he had the same view as we had.
Yes.
But
And-
as I said, at the end of the day, his view didn't count or didn't matter because it was taken away from him.
It was taken away from him.
Yes,
Oh, how do you know that?
because we wondered what happened with the matter.
Yes.
And then he just didn't know the matter was taken away from him.
Did you ask somebody who told you that in the NPA?
Yeah, we asked around. They said, no, it was taken away from him.
And who was it given to, were you told?
I don't know, Chair, I don't know.
Yes,
I don't
but for many years after
Yeah.
that,
Yeah.
nothing was happening about it
That is correct, Chair.
until Advocate Sean Abrahams said it should be pursued.
That is correct, Chair. And then after that, Toshan Pandey filed papers for the permanent stay of prosecution.
Yes,
The state then had to appoint Silk from the Joburg Bar
yeah,
and two other advocates, Advocate Hilton Epstein and two other advocates who are dealing with a civil matter. And it's costing the state hundreds and hundreds of thousands of rands now to get this thing back on the roll, or to fight this thing.
Now, when was it, if you are able to remember, when Advocate Abraham said the matter should be reinstated? Which year?
Chair, this was, if I can recall correctly, I think it was 2017 or 2018, if I'm not
Okay.
correct.
Yes. Okay, somewhere around those years.
Somewhere around the years, Chair.
Okay, that's fine. Ms. Venson?
Now, did you consult with the Silk? Who was that Silk, do you remember? Who was
It was Advocate Hilton Epstein.
Did you consult with him?
Yes, Chair, he came down, he consulted with us meaning myself and Colonel Govender, and eventually he obtained an affidavit from the ADPP at that time, Advocate Silas Ramahiti, and I read through the affidavit of Advocate Silas Ramahiti, and I further confirmed with the affidavit that what is in Advocate Silas Ramahiti's affidavit is true and correct. And that matter is still ongoing.
Well, I see that you say in paragraph 14.12 that after the then NDPP, Mr. Ngasana, had appointed Advocate Ferry Nel and Mr. Andrew Lisk to deal with the case, and that after they had interviewed you, shortly thereafter, Mr. Ngasana and Advocate Ferry Nel were removed. So this would have been around 2015, I would imagine, because I think Mr. Ngasana was removed either in 2015 or 2016.
Yeah, 2015.
Yeah.
Yeah.
Would this not have been the time when Advocate Farinel left the NPA? So
No,
could
Chair,
it
I
be
was-
that he was not removed from the case as such,
Chair, I
but he
finished-
left and then it had to be given to somebody else?
No, Chair, I finished in 2015. And he came and saw us before that, long before that.
Oh, okay.
So that was before August 2015 when I went on pension.
Oh,
It was
okay.
Long before that, yes.
Oh, okay. Well, in that event, probably your statement in paragraph 14.12, that shortly after Advocate Farinel had interviewed you, he and Mr. Ngasana were removed. Probably that's not accurate then, because I guess nobody could remove, I mean, the removal of Mr. Ngasana that you are talking about must be his departure from the NPA as NDPP.
No, he was
you are not
not-
talking about him being removed from the case.
No, he was removed from the case. He didn't resign as far as I can recall, at that time.
But nobody could remove him from the case. He was the big boss there.
No, he was.
He was
We
the
can-
NDPP
Yeah, no,
nationally.
Yes, but I know it's when Advocate Sean Abrams came in after that.
Mr. Abrahams came
After.
after Mr. Ngasana had left.
Yes.
And Mr. Ngasana left either in 2015 or 2016, I can't remember, but it's one of those years.
Yeah.
So, but what I'm saying is,
As far as I can recall, Chair, is that when Advocate Sean Abrams was appointed, that is when it was taken away from him, from Advocate Farinel.
oh, okay, all right. Okay. So that means it would then have been certainly not earlier than 2015, because Mr. Abrahams only came after Mr. Ngasana had left the NPA, and Mr. Ngasana only left the NPA either in 2015 or 2016.
That's correct, Chair.
Yeah. Okay, so the timing you might not be accurate about the timing, but understand what your evidence is. You may continue, Ms. Svensson.
Thank you. Were you told why an external counsel was appointed to deal with Mr. Pandey's application for a permanent stay of execution?
Sorry, I couldn't.
Were you told why an external counsel, instead of an employee at the NPA, was appointed
By the state.
by the state?
Yes, I don't actually recall the specific reasons why private counsel was appointed to do this. But I know it because Advocate Epstein made contact with me and he told me they were appointed to take this matter up in the High Court and defend it. And it's still
But,
pending.
Of course, the appointment of external counsel shouldn't be anything remarkable, isn't it? That happens quite often.
Yes, Chair, it does happen often. The witness had said something to me earlier, but I can't take it further. Then just for completeness, you say that Advocate Epstein drafted an affidavit which was signed by Mr. Ramati. That appears at page 153, which you confirmed in the proceedings.
That is correct, Chair.
Is that the affidavit that you confirm?
That is correct, Chair.
Are you aware what the current status is of the Panda investigations?
You're talking about this application?
Just what is happening in the investigations?
No, Chair, the only thing that I know is it's at a standstill and they are waiting for this silver matter to be finalized before they can actually move further on with that thing. And I'm aware that 466 is presently being dealt with by Advocate Wendy O'Brien from the Commercial Crime Courts in KwaZulu-Natal.
Chair, as from my side, that concludes the witness's evidence.
Okay, thank you. Thank you very, very much, Mr. van Lokrenberg, for coming to give evidence.
Thank you, Chair. It's a pleasure.
If we need you to come back, we'll ask you to come back. But for now, you are excused.
Thank you, Chair.
Thank you
very much.
Tomorrow, did you say that the witness will be
General Libya,
Libya?
yes.
Okay. And then his evidence, I've seen his affidavit, it's not short at all.
It is not short at all.
Yeah.
I suspect it might be the affidavit that you feel that there are a lot of issues that are not contentious and need not be dealt with in great detail.
No, the one that I was talking about is shorter, is much shorter. It may be that his one also has got those features, but the one I had in mind is much shorter than his. We'll have to start at 10:30 tomorrow. Yesterday I said we'd start at 10:30 today, but I discovered that my commitment wasn't going to happen. So we'll start at 10:30 tomorrow.
Yes, Chair.
We adjourn.
All rise.
Accommodation.
Stationery, whatever it is.
And he was using 6
Five. Didn't they say 6? Five, but some were in his
family members. I trust you. Say the president. Yo, dude, my tired is tired. Manje ngoba uyakuzobuyelela ku-broadcasting. I really believe uzobuyela ku-broadcasting. No, you need to reevaluate your life.